In this lecture, we shall discuss the preservation of evidence in certain cases. We shall deal with the preservation of evidence in certain cases. Now, this lecture is important because for criminal trials, there are times when you may want to prosecute a person for a criminal offense, and it may turn out that there's a particular witness that you need to testify. Meanwhile, that person was shot and is dangerously ill. And it's possible that at the time that the main trial will begin, that person may not be available to give evidence. In a case like that, what do you do? So we need to look at how we can preserve evidence in certain cases as far as criminal trials in Ghana are concerned. The first type that we shall look at is preservation of testimony of a witness before trial on indictment or during committal proceedings. Preservation of testimony of a witness before a trial on indictment or during committal proceedings. What does the law say about that? Section 194 of the Act 30, which is the Criminal and Other Offences Procedure Act 1960 Act 30. It provides as follows. Section 194 of Act 30. It deals with depositions of persons dangerously ill. And this is what it says. And I quote, where it appears to a justice or magistrate that a person dangerously ill or hurt, again, a person dangerously ill or hurt, and not likely to recover, is able and willing to give material information relating to an offense triable on indictment. Again, a person dangerously ill or hurt and not likely to recover is able and willing to give material information relating to an offense triable on indictment. The justice or magistrate may take in writing the statement on oath or affirmation of that person and shall subscribe it. Again, where it appears to a justice or magistrate that a person dangerously ill or hurt and not likely to recover is able and willing to give material information relating to an offense triable on indictment. The justice or magistrate may take in writing the statement on oath or affirmation of that person and shall subscribe to it, and certify that it contains accurately the whole of the statement made by that person, and shall add a personal statement containing the reasons for taking the statement and of the date and place when and where it was taken, and shall preserve the statement and file it on record. That is section 194 of the Act 30. It is telling us that when it appears to a justice, I want you to take note of when it appears to a justice or a magistrate that there's a person who is dangerously ill. Not only that, he's also not likely to recover. But that person is able and willing to give material information. And that is when we can proceed and take the statement on oath or affirmation of that person, and the justice or magistrate shall subscribe to it and shall certify that it contains accurately the whole of the statement made by that person. And the justice shall add a personal statement containing the reasons for even taking the statement and of the date and the place where the statement was taken, and we shall preserve the statement and file it on record. So that when the trial begins and the person is even dead, we have the statement of that person to bring it. Sometimes the person who witnessed the armed robbers committing the offense was shot, and it's possible that he may end up dying and may not be available when the trial begins. What do? Section 194 says that when it appears to a justice or magistrate that a person dangerously ill or hurt and not likely to recover is able and willing to give material information, but it must be relating to an offense triable on indictment. So what I want you to note about section 194 of Act 30 is that the section relates and applies to witnesses who are dangerously ill or hurt and not likely to recover. And the witness in question must be a person who is able and willing to give material information relating to an offense, triable, or indictment. So, that is the import of section 194 of the Act. But the question is that when the justice is going to take that statement, is there a need to give the parties to the trial, like the accused person, any notice? Section 195 of Act 30 provides that notice must be given in certain cases. This is what Section 195 of Act 30 says. Where the statement relates or is expected to relate to an offense for which a person has been charged or in respect of whom there has been a committal for trial, reasonable notice of the intention to take it shall be served on the prosecutor and the accused. It is telling us that the prosecutor and the accused must be given notice that this man here who is dangerously ill, he's not likely to recover. We need a statement, so we are going for that evidence. You must give reasonable notice to the prosecutor and the accused. Then section 195, subsection 2. Where the accused is in custody, the accused may, and if the accused so requests, be brought by a person in whose charge the accused is, and an order in writing of the justice or magistrate, to the place where the statement is to be taken. So if you are going to take the statement, and let's say, I am the armed robber, and then I am in custody, and the justice is saying that they want to go and take the statement of a person who they believe is willing to testify, but he's not likely to recover. The accused person, when I'm giving the notice, I'm entitled to be taken to the place where the statement is going to be taken. Let me see the person and let me hear the statement he's about to give. Section 195, subsection 2. Where the accused is in custody, the accused may, and if the accused so requests, shall be brought by the person in whose charge the accused is, and an order in writing of the justice or magistrate to the place where the statement is to be taken. Where the statement is taken, what happens next? Section 196. Where the statement relates to an offense for which a person is then or subsequently committed for trial, it shall be transmitted to the court in which that person is to be tried, and a copy of the statement shall be transmitted to the Attorney General. So when we take that statement, we shall transmit a copy to the court, and a copy must be given to the Attorney General. Remember, we are dealing with preservation of testimony before trial on indictment or during committal proceedings. And it applies to people who are dangerously hurt or ill and are not likely to recover. And that person is willing and able to give evidence. When we take that evidence, the law is saying under section 196 that the statement must be transmitted to the courts on which that person is to be tried, and a copy of the statement shall be transmitted to the Attorney General. Would that statement form a part of the evidence in the case? Section 197 has the answer to that question. And it reads as follows. On the trial of an offender or of an offense to which a statement so taken may relate, where the person who made the statement is proved to be dead, or if it is proved that there is reasonable probability of that person not being able to travel or to give evidence, the statement may be read in evidence for or against the accused person without further proof of the statement. So if it appears that the person is dead or he will not be able to travel to give evidence, sometimes because of the gunshots, he may be in the hospital, he can't even move. So when the person is proved to be dead, or there's a reasonable probability that the person may not be able to travel or to give evidence, the statement that person has given already, it may be read in evidence for or against the accused person without further proof of the statement if some conditions are satisfied. So if A, the statement purports to be signed by the justice or magistrate by or on whom it purports to be taken. It's very important. Before that statement that has been taken will be part of the evidence, we must see the signature of the justice or magistrate before whom it was taken. If he hasn't signed it, then there's no need for us to add it as part of the evidence. Section 197, it says that the statement may be read in evidence for or against the accused person without further proof of the statement if A, the statement purports to be signed by the justice or magistrate by or before whom it purports to be taken. It is very important. The magistrate must have signed it. And not only that, it must have been proved to the satisfaction of the courts that the reasonable notice of the intention to take the statement was served on the prosecutor or accused person against whom it is proposed to be read in evidence, and the prosecutor or the accused or their counsel had or might have had, if present, full opportunity of cross-examining the prosecutor or accused who made the statement. So before that statement can be allowed to suffice as evidence, it must meet the threshold laid down under section 197, that the statement may be read in evidence for or against the accused person without further proof of the statement if A, it was purported to have been signed by the justice or the magistrate before whom it was taken, and if reasonable notice of the intention to take the statement was served on the prosecutor or the accused whom it is proposed to be read in evidence, and the prosecutor or the accused or their counsel had or might have had, if present, full opportunity of cross-examining the prosecutor or the accused who made the statement. That is important to note. So this deals with preservation of testimony, and it relates to preserving testimony before a trial on indictment or during committal proceedings. That is the import of section 194. That when it appears to a justice or a magistrate that the person who is dangerously ill or hurt, and that person is not likely to recover, but the person is willing and able to give material information, then we can go ahead and take that statement, and the magistrate must sign and subscribe to it. And we shall preserve that statement for the record. And remember the conditions, that the person must be dangerously hurt or ill and not likely to recover. And it must be able and willing to give material information relating to an offense, and must be an offense triable on indictment. Remember, he must transmit notices to the accused and the prosecutor. So that is for preserving evidence or testimony before a trial on indictment. Preservation of evidence for trial on indictment. That is for preservation of testimony before trial on indictment. The next to look at is preservation of evidence in anticipation of trial. Because the question that usually people ask is this: under section 194, there's evidence on trial on indictment. Trial on indictment. What if you want to preserve evidence but is no more for a trial on indictment? You want to preserve evidence in anticipation of trial but it's not for an indictable offense. What do you do? Section 200 of the Act deals with that. It deals with evidence of witness before trial. And remember, Section 200 can also apply to trial by summary trial. That when you want to preserve evidence before summary trial, it can apply to it, because look at the language of Section 200. It says that where on the application of the prosecution or the accused, it appears to the district court conducting the preliminary hearing or the trial court that a particular witness will not be available at the trial. So it appears to the district court conducting a preliminary hearing or the trial court that a particular witness will not be available at the trial. The court may, where it is satisfied that it would be in the interest of justice to do so, take the evidence of the witness and cause it to be recorded. What I wanted to note about Section 200 is that nothing is said about a person who is dangerously ill and unlikely to recover. All we are saying is that there's a particular witness who will not be available at the trial. And it is in the interest of justice to do so, to take the evidence of that witness. So under Section 200, we are not told that the person must be dangerously ill and unlikely to recover. We are only told under Section 200 that where on the application of the prosecution or the accused, it appears to the district courts conducting the preliminary hearing or the trial court that a particular witness will not be available at the trial. the court may, where it is satisfied that it would be in the interest of justice to do so, take the evidence of the witness and cause it to be recorded. And under section 200, subsection 2, the evidence may be read as evidence in the court, although the accused is not called as a witness. What I want you to note is that this under section 200, before we shall preserve this evidence in anticipation of trial, under section 200, it must be on the application of the prosecution or the accused. Take note of the difference. When you come to section 194, it says, when it appears to the justice or the magistrate that a person dangerously ill. So when it comes to preserving testimony before trial, it must have appeared to the justice or the magistrate. And the judge can what? Order that you are going to take this evidence. But look at the language in section 200. 200 says that on the application of the accused or the prosecution. So on the trial, section 200 says that it must have been on the application of the accused person or the prosecution. Look at the language of section 200. Where on the application of the prosecution or the accused. So whereas under section 194, we are told that when it appears to the judge, over here, when on the application of the prosecution or the accused, it appears to the district court conducting the preliminary hearing or the trial court that a particular witness will not be available at the trial. The court may, where it is satisfied that it will be in the interest of justice to do so, take the evidence of the witness and cause it to be recorded. And under section 200, subsection 2, we are told that the evidence may be read as evidence in the court, although the accused is not called as a witness. But the person who applies, so you the accused, if you apply that you want to go and take the evidence of this witness, the law says that you must give some facts which are necessary to enable the evidence of that witness to be understood. Because remember, the trial has not even started yet. So for us to gain a full understanding of what the person is saying, you must give us some background as to why we are even going to take the statement so that we can better understand the statements. So under section 200, subsection 3, it reads as follows: that the court may permit the party calling the witness to make a short statement of the facts which are necessary to enable the evidence of the witness to be understood and to be related to the charge, and may also permit any other witness to be called and examined for the same purpose. Let me explain section 200, subsection 3 well. This is preserving evidence in anticipation of trial. We are saying that you, the accused person or the prosecution, you, the one who applies that let us go and preserve this evidence before the trial. We can allow you to make a short statement of the facts so that we can better understand whatever the person is saying. Because this is preserving evidence before trial. No evidence has been taken from anybody. This is the first person we are coming to. Why should we take the statement? So under section 200, subsection 3, the court may permit the party calling the witness to make a short statement of the facts which are necessary to enable the evidence of the witness to be understood and to be related to the charge, and may also permit other witnesses to be called and examined for the same purpose. Let me explain another portion that reads that, and may also permit other witnesses to be called and examined for the same purpose. Let us say that this person that we are saying that we want to preserve his evidence before the trial, because there's a likelihood that he may not be available. Let us assume that when he was giving his evidence, he mentioned some other names. And there's a need that we must also hear from these people. So we are preserving your evidence before trial. We've come to you, but you mentioned some other names. There may be the need for us to also call those other witnesses and examine for the same purpose. That's why section 200, subsection 3 says that the court may permit the party calling the witness to make a short statement of the facts which are necessary to enable the evidence of the witness to be understood and to be related to the charge, and may also permit any other witness to be called and examined for the same purpose. So take note of section 200 of the Act. Now, Section 200, subsection 5. It reads as follows. In the case of an application under this section, the court may order the accused to attend the court for the hearing of the application and on taking of the evidence. So this application that you are bringing, that you want to call this particular person and take the evidence, you must serve a copy on the accused person. Let him come to the court. Let him hear your application. And if the court is also going to take the evidence, let the accused also be there to hear the taking of the evidence. So if the accused person is in custody, we must even give a copy of the order of the court to the one who is keeping the accused person. Bring him here. Let him hear the application. And let him take us to where we are going to take the evidence. Let him also hear the evidence. So what we've done in this lecture is that we sought to just give an overview of how we can preserve evidence before trial. We dealt with section 194 that deals with preserving evidence before trial, on indictment, or during committal proceedings. And remember the caveat: the person in question must be somebody who is dangerously ill and unlikely to recover, and must be able and willing to give the evidence. And 194 only applies to trials on indictments. But what if you want to preserve evidence in anticipation of trial and is not a trial on indictment? You can go under section 200, which tells you that you can apply to the court, and over there's no caveat that the person must be dangerously ill and unlikely to recover. You can apply to the court and seek the permission of the court to preserve the evidence of that witness in anticipation of trial. So this is where we shall draw the curtains on taking evidence as far as criminal trials are concerned and preserving evidence before trials. There's one critical distinction that I would want you to note. And the distinction I want you to note is in respect of the three kinds that we have looked at. You remember in our previous lecture, we dealt with commission for the examination of witnesses under sections 124 to 128 of the Act 30. You remember over there we dealt with the High Court or the Circuit Court issuing a commission to a district court to take the evidence of a particular witness. You remember section 124 to 128. It was in our previous lecture. Now, what I want you to note is that over there under section 124 to 128, the commission for the examination of witnesses, it must be issued during the pendency of a trial. It must be issued during the pendency of a trial. But as you've seen under section 194, which deals with the preservation of evidence of a person who is dangerously ill, under section 194, even if the trial hasn't started, we can bring the application under section 194 because the person is dangerously ill and not likely to recover under section 194. So I need you to appreciate the distinction between commission for the examination of witnesses under sections 124 to 128. Take a critical look. That one must be done during the pendency of the trial. But if it comes to preserving evidence of a person who is dangerously ill under section 194, it can be applied for before the trial because the person is dangerously ill and they can die. Same thing applies section 200. If you compare that to the commission for the examination of witnesses, under 202, you can take the evidence in anticipation of trial. So I need you to appreciate the distinction between these three. For commission for the examination of witnesses, under section 124 to 128, you apply for that commission when the trial is pending. But if you want to preserve evidence in anticipation of trial, if it's an indictable offense, you can go under section 194. If you want to preserve it and it's a non-indictable offense, remember you can go under section 200 of the Act. This is where we shall draw the curtains on the preservation of evidence. Thank you.